Gun owners who want to carry in California and New York have something to celebrate. Recently, GOA's legal team won some huge victories in both of these anti-gun states. And today, we're going to talk about those wins and how they affect you and the future of gun rights down the road. I'm Phil, and you're watching Law and Ammo. But before we get into the video, I want to take a second to let all of you know about GOA's alerts. Our alerts help you keep up to date with all of the latest victories or attacks on your right to keep and bear arms on both the federal and state level. Signing up for GOA's alerts will help you hold your elected representatives accountable to your rights and the Constitution. And so sign up today with the link in the description or visit gunowners.org. And now back to the video. So gun owners around the country who want to carry in both New York and California have something to celebrate, as out-of-state carry permits just became much closer to obtainable thanks to some court victories and moves by local governments. As you may have already guessed, there are two different lawsuits here. Higbie v. James is GOA's New York case, and California Rifle Pistol Association v. Los Angeles Sheriff's Department is our case in the Golden State. First, let's talk about the New York case, Higbie v. James. So the aforementioned Higbie in Higbie v. James refers to none other than Carl Higbie, host of a primetime news show on the Newsmax network. Higbie is also a former U.S. Navy SEAL. Currently, New York doesn't allow out-of-state residents to apply for carry permits. Higbie, who lives in Connecticut, wanted to apply, but at the time, there wasn't even a process for him to do so. Two other individuals are also included in the suit, Joseph Harris and Michael Vitruba, both residents of Massachusetts. Vitruba owns a property in Berkshire County, Massachusetts. His property borders New York State. And if he was carrying and unknowingly walked into New York, he could, by no fault of his own, become a felon. And because New York doesn't allow him to apply for a permit, there's currently no way for him to make sure that doesn't become a reality. All three plaintiffs currently possess licenses to carry firearms in their home state, but New York unfairly disqualifies them for no reason other than arbitrary firearms restrictions set in place by anti-gun politicians. So we filed a lawsuit on February 5th, 2024 in federal court, specifically the U.S. District Court for the Northern District of New York. We were assigned Judge May Avila D'Agostino, an Obama appointee, and currently the case is proceeding. And we most recently went into mediation with the state, but we haven't settled that case yet. However, and very interestingly, New York City just recently issued an emergency rule allowing non-residents to apply for carry permits. That's kind of interesting timing. Now you can get a New York concealed carry permit and carry a firearm for self-defense in New York City, and nobody had that on their bingo card. But I'm sure glad we filed our lawsuit anyway. Here's what Eric Pratt, Senior Vice President of GOA, had to say. This is great news for the untold millions of Americans who either work or visit New York every year. It's critical that everyone can exercise their inherent right to self-defense. But until now, anti-gunners in New York denied most Americans that basic right. We will continue to monitor local cases to ensure that the NYPD indeed grants these permits to applicants in a timely and non-onerous manner. Otherwise, we will gladly file another lawsuit directed specifically at Mayor Adams and the NYPD. While currently New York State doesn't allow for non-residents to apply for carry permits, New York City does. New York City has a separate permitting system from the state, but it seems like the city saw which way the wind is blowing in this case. We'll see what happens, but we're hopeful that New York State realizes the error of their anti-gun ways very soon. Moving on, let's check in on what's happening on the other side of the country. GOA, GOF, and gun owners of California teamed up with the California Rifle Pistol Association and the Second Amendment Foundation to file a lawsuit in the U.S. District Court for the Central District of California. So, we are all plaintiffs in the suit, CRPA v. Los Angeles Sheriff's Department and Attorney General Rob Bonta. In a similar situation to New York, California flat out denies anyone out of state the ability to apply for a California carry permit. Well, that is until now. The judge in that case, Sherilyn Peace Garnett, wrote that the state failed to demonstrate why they infringe on the right to bear arms for non-residents visiting California. The state argued that there were historical analogs for denying out-of-state permits under the Bruen decision, basing that argument on laws from other states, although the laws cited were from the 20th century. The judge disagreed with the state's assessment, saying the state has not carried its burden at this stage to show that the limitation of CCW licenses to California residents is part of a historical tradition of this nation. But why is that important? Well, for those who don't know, the recent Supreme Court decision, New York State Rifle and Pistol Association v. Bruen, requires that all Second Amendment restrictions show a historical analog and that they comply with the text of the Second Amendment. Otherwise, they're deemed unconstitutional. So California decided to use examples for state restrictions during the 20th century. The problem with that is that Bruen requires a historical tradition from the founding era of the nation. Later gun controls that were enacted but not challenged from the Civil War era to the modern era don't automatically count because they were actually just infringements. It's really cool to see the Bruen decision in action and working to dismantle gun control. Now the next step here is to enjoin the law, which was ordered to happen within 30 days. Right now, plaintiffs are meeting with the state to submit a proposed order enjoining the law. So it looks like out-of-state permit denials are becoming a thing of the past. Currently, the only other state that doesn't allow out-of-state carry permit applications is Hawaii. Hopefully, this decision will help cases overturn that as well. We're of course going to continue fighting in New York State until they relent like the city did and change their rules. And as always, GOA will continue to fight for your right to carry a firearm nationwide. I'm Phil with Law and Ammo. Thanks for watching.